In Mexico, the lottery is used as the final method of appointing electoral magistrates when there is a lack of consensus to fill the vacancies. The process is governed by the federal constitution, which grants the Senate full discretion to decide who will occupy the position of electoral magistrates from the lists proposed by the Supreme Court of Justice of the nation. It is important to note that this constitutional power involves the participation of two branches of the republic, namely the legislative and judicial branches. Therefore, it is crucial to respect the scope of responsibility of each branch in making these appointments. The appointment of electoral magistrates is a current procedure that requires careful consideration and adherence to constitutional guidelines. On this last aspect, it is worth insisting that in the final phase for the appointment of electoral magistrates, the construction of a political agreement is required that involves as many political forces as necessary to achieve a qualified majority of 2/3 of the members present. In other words, the power of appointment and the construction of the necessary consensus is what the jurisprudence of the Supreme Court of Justice of the nation and the TEPIF have referred to as political issues, which in this particular case, being powers expressly conferred to the upper chamber, are not capable of being disputed through any means of judicial control or intervention. In this order, there is no possibility in the constitutional norm for the highest judicial bodies to order the appointment of judges of equal or lower hierarchy due to any legislative omission, as that decision would imply transgressing the principle of separation of powers in its aspect of due deference to the autonomy of the legislative power, which is a fundamental pillar of democratic governance. In that sense, the consensuses or majority political agreements typical of parliamentary debate, by their own intersubjective nature, are exempt from judicial control, and therefore are protected by the Constitution as acts inherent to the legislative function expressly conferred to that power. For the identical reason, the intention to order, by means of the power of the sentence, that a parliamentary agreement be achieved within a specific period of time, represents an act that has the potential to result in the abuse of judicial review, as it entails arbitrarily and unlawfully encroaching upon the constitutional powers of a duly established authority. Certainly, even though it constitutes a constitutional irregularity, the lack of appointments of the members of the top judicial bodies, specifically in electoral matters, it cannot be ordered in a judicial setting to force the respective parliamentary agreements. This has happened, for example, with the vacancies that currently exist in the Superior Court, the regional courts, and the local courts, whose appointment processes have not been able to be completed by the Senate to appoint the 50 available magistracies in this regard. It should be noted that an additional benefit of incorporating the method of drawing lots in the final stage of the appointment of electoral magistracies would be to prevent the irregular integration of the electoral courts, as the magistracies originally appointed by the judiciary, or the legislative power, have ceased to function, and have been replaced by people designated by the plenary sessions of the respective jurisdictional bodies. Without there being a regulatory backup to guarantee the suitability of the designation or hypothesis for the respective substitution, nor a specific deadline for that enablement, especially since experience shows, in the face of the current paralysis in appointments, due to the lack of political consensus, that the absence of agreements can last even several legislative periods, and, consequently, judgments have been issued by jurisdictional bodies composed of magistrates in office, which represents an anomaly in the electoral justice system that must be corrected as soon as possible. Undoubtedly, there is an urgent need for conclusive reflections on the modification to the current system of appointment of judges of last instance in Mexico. There is a perception among citizens that the federal and local judiciary is the branch of government that is most distant from the needs of the people, and as a result, it is crucial to respond to the social demand for democratizing the judiciary. Specifically in regards to the electoral jurisdiction, such modification to the appointment method can be addressed through a constitutional reform, but it could also be implemented through the corresponding reform to the general law of electoral institutions and procedures and the organic law of the federal judiciary, in order to ensure that the appointment method for electoral magistrates guarantees profiles whose only commitment is to respect the separation of powers, the effectiveness of fundamental rights, and the strengthening of institutional culture. The lack of transparency in the evaluation process of the individuals considered for the electoral magistracy hinders the availability of specific information or data regarding how the external candidates, who are sent to the Senate by the Supreme Court of Justice of the nation, are defined and selected. Such lack of transparency prevents considering the procedure democratic, but also, such omission about the evaluation parameters could have an impact on the institutional culture of the members of the local electoral chambers and tribunals. Regarding this, I propose incorporating minimum elements into electoral legislation to evaluate the relevance of candidate individuals, as there should be an open competition for all society, in order to strengthen the institutional culture of the judicial power and local courts. This is, once the technical and experiential aspects have been evaluated, to provide the final stage of appointments with the method of random selection, in order to ensure the necessary independence and exercise of prudence for guaranteeing self-restraint in the exercise of judicial function. It is crucial to establish objective parameters to define the optimal profiles that would be included in the roster of candidates for the vacant magistracies formed by the Supreme Court of Justice of the nation. Regarding this, I believe that the highest averages from the technical evaluation, which includes a written exam, essay, and interview, should be the only ones to be considered as members of the corresponding list. And to avoid paralysis in the appointments of electoral magistrates due to the lack of the necessary constitutional majority, I propose adopting the method of appointment through random selection of the members of the local electoral courts and tribunals, specifically in the final phase of the procedure that the Senate of the Republic is responsible for implementing. Moreover, beginning with the public lottery, I think it could also be feasible to deviate from the direct obligations resulting from top-down interest group or political negotiation decisions, as chance would determine the final decision on the integration and allocation of elected officials. The institutional deference between the powers of the Union prevents specific attributions, such as the appointment of electoral magistrates, from being subject to judgment. Therefore, it is forbidden for the judiciary to interfere in ordering political agreements, and even less in making direct appointments, thus safeguarding the integrity of the appointment process. In that sense, an additional benefit of incorporating the method of drawing lots in the final stage of the appointment of electoral magistrates would be to prevent the irregular or anomalous integration of local electoral chambers and courts, as the magistrates originally appointed by the judicial power or the legislative power have currently ceased to function and have been replaced by magistrates in office appointed by the plenary sessions of their respective jurisdictional bodies, without there being any normative support to guarantee the suitability of the appointment or a specific deadline for such authorization.